Richard Pratt ran the enormous Visy paper company. He had sometimes hired an escort named Madison Ashton. Their relationship developed, and he asked her to stop working as an escort. He promised to pay her a lot of money and to leave more to her children in his will. You can see the arrangement was more than prostitution, but less than a relationship. Ashton accepted the arrangement, but managers from Visy later paid her money to stop her from maintaining the claim. In 2009, Pratt died. His will did not contain bequests for Ashton's children. She sued to enforce his promise. The matter was decided on a number of grounds of contract law. Along the way, though, Justice Brereton added a whole new issue, one that neither of the parties had pleaded. He said, correctly, that for many years the law had held that contracts prejudicial to the status of marriage were contrary to public policy and could not be enforced. He was concerned this might be such a contract. He held this concern despite both Ashton and Pratt being grown adults who had entered this arrangement knowingly and voluntarily. It's difficult to avoid the conclusion that Justice Brereton simply appointed himself as the defender of marriage. He accepted that public perceptions of marriage had changed over time. He said, changes in social mores have resulted in a more liberal attitude, but the old rule has not been completely obliterated. The question is, what is its remaining content? He then failed to consider that question. He couldn't. The parties didn't raise this issue. He had no evidence. He had no way of knowing the public view on this issue, no way of determining where public morality lay, other than by relying on previous old cases. So that's what he did. He found no case stands contrary to the proposition that it is still the law that a contract to provide meretricious sexual services is contrary to public policy and illegal. While social mores have no doubt continued to change, as authority stands, such a contract remains contrary to public policy and illegal. On appeal, the parties still didn't argue this point, so the Court of Appeal didn't consider it. As a result, this decision stands, troublingly, as fresh authority that contracts establishing relationships involving sexual services are still contrary to public policy and unenforceable.